Hello everyone. Now we will talk about economic rationale behind providing patent protection and what does empirical evidence provide us. What do you mean by empirical evidence? Essentially, here we will talk about the different studies which are based either on a country or cross-country data and see the different hypotheses which are being raised with respect to the impact of patent protection, patent policy changes on innovation and technology transfer, whether those hypotheses are verified or not. If not, then what are the possible justifications? Are there certain conditionalities attached to that? So before we go into that, let us first talk about the economic theory and the reason it gives behind providing for the patent protection. Market failure in the markets of technology is an important concern. Why it happens? As a student of economics, you must have heard about public goods. Public good has two major characteristics. One, non-excludability. Another is non-rivalry. So if you go by definition, public good is non-exclusive and non-rival good. And essentially, it means that the marginal cost of making provision for an additional consumer or providing one more commodity to a consumer is zero, and people cannot be excluded from consuming it. Public parks are one very common example of such public good. Non-rival good essentially means good for which the marginal cost of its provision to an additional consumer is zero. Is a good rival in consumption? What does it mean? It means it does the consumption by one person reduces others person chances to consume it. Like I gave you an example of an apple. If I have it, you cannot have it. On the other hand, non-exclusive good means good that people cannot be excluded from consuming it. If there is a highway and there are no toll roads, then definitely anybody can go on that particular road and use it. And moreover, it is also very difficult to exclude. On the other hand, once you put the toll, clearly it will be possible to create some kind of a situation whereby excludability is possible. Essentially, in excludability, we talk about whether a person can be prevented from using it or not. And in non-rivalrous, is we ask the question when the consumption of one person reduces the ability of the other to use it. Now, against this definition, let us try and understand what is it that about the knowledge. Knowledge is something which is definitely a public good because once you have a product, let us say, which is knowledge-based product, it is very easy to imitate it. Then what you will find is the cost of production of an additional unit would be rather very limited. And also, it is very difficult to exclude the other group of people from learning from it. Let us understand with an example. This is an example of a drug development. In the recent times, we have gone through a pandemic, and during that time, we realized how important the new drugs is. But the development of these drugs involves immense resources, and those resources are being spent by the different companies. Now, once let us say a drug has now come into the market, and after that, it will be very easy for anybody else to kind of copy it, and essentially the cost that is associated with providing one more unit of that particular drug to the market is effectively merely the cost. If the market is perfectly competitive, from your earlier classes in economics, you will know that the price will become equal to the marginal cost, leading to a zero economic profit. Now, think from a point of view of a company or a firm which has initially spent a lot of money on the development of this particular drug. If how are they going to recoup it? How they are going to recover the investment that has been made in this research and development, because the price has now fallen to the cost of production itself. What about the initial cost which was being spent on the drug development? The fixed cost associated with new product developments in that case will be very difficult to recover if the firm will be leading towards a competitive market. Under this circumstance, a kind of a patent protection which will lead to a time bound or a limited monopoly to the producer will provide them an opportunity to recoup, or as I said earlier, recover the investment that has been made in their research and development. So essentially what we face in this case is that there is a trade-off. What do you mean by trade-off? So on the one hand, we want people to invest in the research and development. On the other hand, we have created a situation whereby what means being sometimes being also referred to as a state-sponsored monopoly. What is the impact of the state, such kind of a state-sponsored monopoly on the market? Let us try and understand from a very simple example and a diagram which you would have done in your earlier microeconomics classes. On the x-axis, let us say quantity supplied and the quantity demanded, and on the y-axis we have price. What we have in the market is a downward sloping demand curve. In a perfectly competitive market, from your earlier studies, you know that there are large numbers of buyers and sellers. And in such a situation, what you have is each seller now becomes a price taker. So the price is effectively being equal to the marginal cost of the production. So in a competitive market, the price is effectively equal to marginal cost of producing that particular good. The total quantity which is being now supplied in the market is equal to QC. I hope all of you are well aware of this very basic diagram. Now, in case if a monopoly exists in a particular market, we know that profit maximization situation is where your marginal cost is equal to marginal revenue. Why so in this case? I hope you remember that in case of a perfect competition, whereas one firm is a price taker, they will be able to sell all the commodities at a particular price being determined in the industry, whereby the demand and supply forces come together. Whereas in case of a monopoly, in order to sell more units into the market, the monopolist has to reduce the price. That will effectively mean the total revenue will also be affected by as the price will go down. So what a monopolist will take into consideration is the marginal revenue that they will get by selling one more unit and its relationship with the marginal cost, that is the additional cost incurred to produce one more unit of the output. Marginal revenue curve can be deduced from the demand curve, and this will be your marginal revenue curve. You can see that for a monopolist, the equilibrium point as determined by the profit maximizing condition is where your marginal cost is equal to marginal revenue. Let us call this point E0, EM, and let us call this point as C. So now, after having determined this particular point will actually determine how much quantity will be supplied by the monopolist in the market. So that will be equated to now QM. Now what would be the price that will be charged by the monopolist? Again, for this particular quantity, the price as per the demand curve would be somewhere around PM. So what is the impact of a monopoly in such a market? Two conditions are very clear. First of all, the quantity which is being supplied by the monopolist is less than the quantity that will be supplied in a competitive market. Not only that, the price that will be charged by a monopolist is also going to be greater than the price which is being charged in the competitive market. Now, who is going to bear the impact of this kind of a existence of a monopoly? Clearly, consumers are going to be affected by the prevalence of monopoly. Essentially, you will realize that the consumer, in fact, get affected through two channels. One is the reduction in the output, and another is the increase in the prices. So, that means there are certain consumers who will now be driven out of the market because, first of all, the output has also declined and they will not be able to afford the commodity at that particular price. If you look at the diagram, it effectively means there will be a reduction in overall the consumer surplus. I hope you remember from your earlier classes that what do you mean by consumer surplus? In a very simple way, consumer surplus is an area above the price, below the demand. Consumer surplus is essentially being determined by an area below the demand curve and above the price line. So the area which will be covered in this would be your consumer surplus. That has clearly gone down. Another important impact of the prevalence of monopoly in this case would be reduction in the consumer surplus. So if I look at the consumer surplus under the competitive market, it will be determined by the area of A, PC and EC, essentially from this point to this point and this point. You will see that this is an area below the demand curve and above the price line which we have here. On the other hand, if I look at the consumer surplus under the monopoly, it will be determined by point A, PM, and let me call this LM. So visually itself, you can find that the change in the consumer surplus is in fact has led to a reduction in the consumer surplus. So let us now compare these two areas. Clearly there is a decline in the consumer surplus. However, let us first look at this particular area marked by the blue pen. What is going on in this? This reduction in the consumer surplus has actually shifted in form of profits for the monopolist. What concerns the policymakers essentially is this green area. Where is this green area emerging from? Effectively, because now the output in the market has reduced, that means some of the customers are now left unserved in the market. They do not have access to that particular drug because the price has increased. And this is very popularly known as the deadweight loss. So where are we headed with this? Essentially, if we were talking about the provision which is being made for the patents, and we said earlier, the idea here is to allow the firms to invest in R&D so that through this so-called limited state-sponsored monopoly, they will be able to charge higher price, and in the process, they will be able to recoup or remake the investments that they have made in research and development. However, now we look at the flip side of the monopoly. The flip side of the monopoly is that the number of the units that might be provided in the market are going to be less as compared to the competitive setup, and society will also suffer from the deadweight loss, which is now being measured through this area of LM, EM and EC. And that happens because, as we could see from the diagram, the prices charged are higher, output provided is less, there is a reduction in an output as we move from competition to monopoly, and there is an increase in prices leading to the reduction in the consumer surplus. So then what we have a trade-off in the sense that static, there are losses. That means for a time duration, for a time period of this 20 years, because of the patent, there is going to be a deadweight loss to the society. So that is what we being refers to as a static losses in the literature. On the other hand, what we have is an incentivization. We have this motivation being given to the firm so that they come forward and invest in research and development. So that is what this trade-off is effectively about between the static losses in the form of the deadweight loss and the dynamic efficiency. So where is this dynamic efficiency coming from? The dynamic efficiency is essentially coming from the increase in the research and development investment that will be undertaken by the firms. So in that context, some important question arises: do patents really create monopolies? Now, first of all, let us be very clear on this aspect that the patent do not restrict access to information. In fact, if you look at the disclosure requirement in the patent, that essentially means that in lieu of the grant of the patent, what the inventor will be giving the patent office is the full information about the invention. In the patent application, they have to provide the details of the working of the particular patent. They also have to give the diagrams or whatever may be necessary to explain what the invention is all about. So in that sense, clearly, the access to information about that particular invention is available, and it is available in the public domain. If you remember from my earlier class, I have made it very specific there that access to information has been provided with the idea that it will lead to more and more technological change. In fact, it will support more technological change, as has been said by a very famous scientist, that if I have been able to look so far, that is because by standing on the shoulders of the giant. What does it mean? It means that the knowledge we need to have an access to an earlier information to build on it. So clearly, in that sense, they may not restrict an access to information as such. Moreover, patents are territorial in nature. that we also discussed earlier, whereby we talked about how a patent right will be applicable within the geography of the country in which it has been given. Apart from that, we have found that the companies and the firms may in fact use different other means to appropriate their intellectual property. What are those means? For instance, a first mover advantage. If a certain company has introduced a particular drug in the market first, as a result, over a period of a time, it develops a certain reputation and people become loyal to the product of that company. And they have been able to establish a certain kind of a brand loyalty because of that particular maybe first mover advantage, or maybe because of some other reasons. As a result, even if there would be competitors of the same product in the market, what you will find is that the consumer will still go back to the same company. They are ready and willing to spend a bit more and give more money to the company because of the reputation or because of the brand loyalty that they have towards them. Apart from that, there can be entry barriers in a particular sector. So that can also be used by the companies instead of merely using the patents to restrict the competitors from ensuring and providing imitative goods in the market. Apart from that, trade secrecy has been also treated as one very important way through which the companies will be able to appropriate the intellectual property that they have created. So if there are alternatives available, that means the companies will not be merely using the patents to monopolize a particular market. They have other means also. Apart from that, another important point is the availability of the substitutes. It is possible that certain other substitutes, maybe a lower quality one or the one with a relatively lower features, might be available in the market. Clearly, the case of pharmaceutical and drug is a bit different, whereby once a particular drug has come, and if it is it is a drug which has been like a magic drug or is being treating a particular disease for which no other alternative is available, under those circumstances, there will not be substitutes that are available in the market. So now, to sum up the discussion we are having, on one hand, we have the reasons as to why the patents are being provided, and on the other hand, we have the costs that are being imposed on the society for providing the patents. First of all, the major reason and the motivation is to incentivize the firms to undertake innovation, not to fear the imitators and be able to come up with the newer ideas and the newer products. That would essentially mean that the companies will be ready to take investments in the particular. Now, this project, essentially the research and development related, are going to be higher risky. So because of this confidence that they will be able to survive in the market and will be able to beat the competitors and their imitative product through the patent mechanism, the companies will be much more ready to take risk and also commercialize the newer products. In terms of the cost, if we look at it, the cost is imposed on the society, first of all, with respect to the higher pricing. As we have already seen in an earlier case, that when the monopoly has been granted, that means the prices that will be charged by the monopolist are going to be higher than the price that will be charged by a competitive firm. The studies have also pointed out that providing patent protection may actually lead into a kind of a race among the firms, and the race among the firm would be to get the patent in a particular sector or in a particular technology. They might be overspending. They might be spending too much resources, not only on not only on the innovation itself, but also on the getting of the patent itself. The studies have also highlighted that there is a limited diffusion of the information through the patent documents. In fact, many people are not very well aware of the usage of the patent document in order to learn about the recent technologies. As a result, it has led to a limited diffusion of the information that in fact has been a major reason as to why patent has also been granted, essentially to get an access to the information about how the invention works. Another important point is that the research and development motivated by getting a patent or through the patent race may actually move into a direction where the patents are possible. In fact, if you look at the basic research, it will be very difficult to get the patent in that area with respect to the discovery or with respect to coming up with a mathematical model so in those conditions the research will be more and more towards the so-called hot areas, whereby the more and more technological development is going on, leading to an overinvestment in certain situations. So effectively, there are reasons as to why the patents has been provided. In order to sum them together, four major reasons has been talked about McCullough in his 1958 work, whereby the first is that the natural right, because the person who has now created this invention or who has undertaken the creative activity and has led to an outcome on one form or the another, in fact owns it, because it is the outcome of the hard labor of that particular person. Apart from that, there is a motivation to incentivize the person or the firm to invest more in research and development. So if the monopoly is given, they will be able to make profit, and that profit can be further used to support the future innovation activities. Please note, in a competitive setup, when the price will be equal to marginal cost and the companies will be making what is known in economics as zero economic profit, then there is no scope to have resources that will support your future research and development investment. As a result, that will lead to a reduction or an underinvestment in innovation. The last point which McCullough has pointed out, is with respect to the disclosure, exchange for secrets. The monopoly which is now being given is in essentially to get the information about how the invention works. So in that context, there are reasons as to why patent provisions has been made. And as we have seen in the historical context, that has been available since 15th century and has also spread at a very fast pace in the other countries, starting from European countries. On the other hand, there are definitely costs which has been imposed. So what we are thinking from a point of view of a policy maker, essentially, there in an absence of an IPR, as Professor Park has pointed out, it will lead to an underinvestment in innovation. Whereas the presence of IPR may lead to an overinvestment in some kind of an innovation, like I said earlier, in the hot areas whereby you will find that more and more work is going on. In the recent times, people might be investing more in AI or electric vehicles in order to get the recent patents. So essentially, the idea in that case would be to balance the underinvestment and the overinvestment in these circumstances. One way could be through the support of the government for the research and development, particularly in the basic sciences. Now we move on and we talk about the empirical evidence. Before I get into the empirical evidence, I will talk about what do you mean by this. As I said earlier, here, once the hypothesis has been raised based on the theoretical model, the issue is whether the hypothesis is verified using the real-time data. So what we do, most research in economics will be focusing on collecting information either from a particular country or from a different set of countries, sometimes from firms which are located in a country or firms which are located around the countries. They might even get information on a patent. Apart from that, they may even conduct surveys to know about how firms patent and why firms patent. And then that particular data which has been collected is now different kind of econometric techniques are used to find an answer as to whether the hypothesis is verified or not. So if we look at that set of studies which has actually looked at data and applied different techniques to verify the hypothesis, what do we get? Now we have looked at the theory and we have found the reason as to why the patent should be provided. So let us also look at what the empirical evidence support and what it does not support, and whether it also adds on to the discussion with respect to the provision for patent right and the impact. The impact is in the form of creating more innovation and also to an extent supporting the technology transfer. One of the most influential work by Cohen et al. In their initial surveys has in fact shown that the firms are more and more interested in the alternative mechanisms. If you remember, just some time back, we talked about the different means of appropriability that are available with the companies for appropriating their intellectual property. The study of Cohen et al. Is actually based on a survey. And that survey has shown that the firms use different methods. They use secrecy, they use lead time, they use production cost reduction, superior marketing, and as a result, there are also country-wide variations in terms of these responses. And As a result, patent is one of the means or one of the mechanism which is being used by the firm to appropriate their intellectual property. One very important result which we find in the empirical work is with respect to the sector specificity. That means there are certain sectors which are more patent intensive and which are like pharmaceutical and chemical. In those sectors, you will find that the firms are more and more interested in essentially using patent as a means for protection. Apart from that, important factor in terms of determining whether in a particular sector patent holds an significant position to appropriate IP is based on what are the imitation cost. If the imitation cost is very low, then clearly there will be a motivation for the firm to protect their inventions or the IP through the IPR mechanism or through the patents. On the other hand, if the imitation cost itself is very high, there are high barriers to do this kind of an R&D and then introduce the product in the market, then IP may not be that much of a relevance. Another important critique of intellectual property right is that given that we have a sector specificity in terms of whether patents are important for innovation or not, then all countries has in fact made a provision for it. That means we have found an approach which is one size fit all, which may not be relevant. There are various studies which have actually talked about how patent reforms has not been very significant. Learner in their empirical study examined 177 events of patent reform over a period of 150 years in 51 countries. Patent reforms in the sample countries included enactment of patent law, changes in the duration of rights, fees, and inclusion of provision like revocation and compulsory licensing that will weaken the rights of the right holder. The study found that the patent reform did not affect patent filing by residents in a benchmark country, that was Great Britain. The relationship between patenting policies and firms' innovation activity in that case is not straightforward. Moser has suggested that the policies that grant patent to early innovation in fact discourage overall innovation in the industry. However, patent policies that encourage diffusion of technology and competition in the market may indeed stimulate innovation. A work by Baldwin and Levin has argued that they in fact has dismissed the role of patent policy in increasing the innovation and productivity. In fact, they argued that the mature industries with diminished growth has potential use of patents to become more and more concentrated. And in fact, they have argued that there is no evidence to suggest that the patent protection supported the initial innovations in the new industries like radio, television, and computers. So, in that sense, there are studies which support patent protection as a means for the innovation. On the other hand, there are a set of studies who argue that the patent protection has not been very effective in determining innovation. One important characteristics that come through is that there are sector specificities, and clearly this approach of one size fit all can be reconsidered. The another important point is with respect to the economic development and the role of intellectual property right. If you remember our discussion on TRIPS agreement, then we have talked about how this agreement has led to making provision of the minimum standards with respect to 7 types of intellectual property in different developing countries. One question at that point of a time was also being raised by the developing countries that to what end? What is it that we are going to gain for making this provision? Invariably, this is leading to an increase in the right of the right holder. What do we mean by this? Say for instance, in case of India earlier, product patent was not granted in pharmaceutical. That means somebody could actually reverse engineer the drug and learn from it, maybe make certain tweaks in it, can also get a patent a particular process. However, after the introduction of the product patent, that means now it is much more difficult to imitate a particular technology. That effectively means that the right holders, his or her rights has now been strengthened by this particular change. Similarly, earlier, if the duration was 14 years, which is now being extended to 20 years, clearly it means that the right holders' rights has been strengthened in the domestic economy by making changes as per the TRIPS requirement. Now, the question, as I said earlier, was being raised in the context of the developing countries as to what is it that they are going to gain. And in that context, what we find once again, a lot of empirical studies has been conducted to understand the role of intellectual property rights in economic development in the context of developing countries. An important work by Chen and Putnam has highlighted a U-shaped relationship between intellectual property right provision and the innovation, pointing out that some of the developing countries, in fact, during the initial stages, might be dependent on imitation as an important way of learning and developing their technological capabilities. If some countries are indeed learning through imitation and the provision for intellectual property rights is increased in such a countries, clearly the innovation is likely to reduce. On the other hand, after reaching a certain level or a certain stage of technological development and its capabilities, there is a possibility that the countries will now gain from making provision for strong intellectual property right. Why? Because the innovation effect is likely to now dominate the imitation effect in an earlier stage. So, say for instance, we have taking intellectual property right provision and innovation on y-axis. So essentially, the study talks about two types of effect. One is the imitation effect and another is the innovation effect. So during the earlier stage of technological development, the imitation effect may dominate because this is how the firms are learning. They are bringing maybe cars from another country, they are trying to dismantle them, learning what is going on in them, and then maybe try to put them together. And that particular process is important in the learning curve. So imitation is an important source of learning. However, once a country reached a certain level of technological capabilities, what you will find that the innovation effect becomes important because now the companies in that particular country are very innovative. They are spending resources on research and development and they are capable of coming up with the new to the world innovation. So during that stage, making stronger provision for intellectual property right is likely to increase the innovation. On the other hand, if it is stuck in an earlier stage where imitation is an important source for learning, what you will find that the innovation will actually come down if you increase the provision for intellectual property right. So this kind of a U-shaped relationship has in fact been also empirically supported. In the context of the developing countries, clearly the relationship between innovation and intellectual property right in that sense is conditioned by the level of economic development because it is the level of the economic development which is going to influence its technological capabilities and also what it can or not do. If you look at the empirical literature, in that context, what we find is a Snyder who has examined the effect of patent protection on innovation, essentially measured using the number of US patent application filed by residents of a given country. And the result, in fact, has for the full sample of the studies show that the innovation respond positively to patent protection. However, after splitting the sample into developed and developing countries, patent has a significant negative impact on the innovation in the developing countries. Similarly, Allited and Park has also shown that the middle income developing countries raising patent strength has in fact a negative effect on their domestic innovation. They attribute this negative coefficient to their imitative, adaptive, and non-drastic innovation that undertake place in the developing countries. Sharma et al., in the context of a developing country like India, they also find that the patent policy changes, specifically increase in the protection duration, enforcement, membership, has positive effect on the R&D intensity. However, the overall effect has not been that significant. So clearly, the level of economic development of an individual country clearly influences what kind of a gain that country will have by making stronger provision for intellectual property right. The another important point that has been raised is with respect to the strategic use of the patents by firm. Firms may in fact actually engage in different types of activity which might be anti-competitive. For instance, they might be, they might be blocking the patents, they might be merely patenting in order to build their patent portfolio so that they can fight with their competitor or negotiate with their competitor better. And this kind of a behavior will actually influence the competition in the market. The strategic use of patents by firms clearly can come under the anti-competitive activities, and the individual countries competition act and or the antitrust authorities can take care of that. Lastly, I would like to highlight for the researchers of future that there are increasingly important challenges in the studies which effectively look at the empirical relationship between patenting and innovation. In that context, please understand our theory, which suggests that if patents are not being provided, then the investment will not happen. Now, how do you create a counterfactual to the existing situation in that case? So, the question has been raised that if we can provide an answer that if the patent provision was not created, then these inventions or innovation would not have come into picture, then we will have a very concrete evidence of the relationship between patent policy changes and the innovation. On the other hand, what we have, if you look at the current literature, is most of the time is a variation in the patent right across the countries and the innovation that happens in those countries. Apart from that, it could be in an individual country provided it has introduced some major change. So, what we are looking forward in future is development of certain methodologies which will be able to deal with this kind of a challenge in the empirical research. So, with this, we end our discussion on intellectual property right. We have looked at what intellectual property rights are. We, in particular, in detail, we have understood the differences among the different types of IPRs. We also looked at the different institutions which has been created and an historical account of the reasons for those institutions that has been created, like WIPO and under TRIPS agreement, under WTO and domestic legislation, in order to support the IPR regime of particular country and that of the different countries at the international level. The next part which we have done in this context is to understand the economic rationale behind providing provision for the patent. And lastly, we have done also the empirical evidence behind the relationship that exists between patents and making provision for patents and the innovation that in being undertaken by the firms.